Hello ladies and gentlemen, welcome back to this channel. My name is Esther and today I'm talking about offer and acceptance. I want to thank you for all those who've been watching the videos and the comments, and I'm just responding to one of the comments that requested that I make a video from the law of contract with respect to offer and acceptance. So here we are. I hope you're able to follow and understand these concepts because they're quite easy actually. So we want to start with the offer. What is an offer? In law, an offer is really an expression of interest to be subjected to certain contract terms. In other words, you're offering to buy something, you're offering to do something, you're expressing your readiness, you're very ready to do something. That's an offer. Now I want to point out three different types of offers because the offers determine these different types of offers can either be valid in law or not valid. Remember, we said for a contract to be valid, there has to be a valid offer and valid acceptance. So one of the offers that is not valid is a counter offer. And what's a counter offer? You know how you go to the market and you say, I want to buy tomatoes for 30,000, and the guy is like, no, these tomatoes, this bucket will only cost you 50,000. So you offer 30,000, he offers 50,000. You say, okay, let's make it 25. You know, you're haggling or you're bargaining. Those are counter offers. Now, in law, a counter offer invalidates the original offer. So if you say you're offering to buy the kilo of rice at 10,000 shillings, that is your offer. Then the shopkeeper, then the person buying it says, no, I'll give you 9,000 for it. So they have made another offer. That is a bargain, a counter offer. So their 9,000 shilling offer cancels out the original offer you made of 10,000. So you say, no. Okay, instead of 9,000, let's make it 9,500. So when you make it 9,500, that's another counter offer. So in law, these offers or these bargainings or these negotiations, each new offer cancels the original offer. So at the end of the day, the offer that is on table is the most recent. The last one is the one on table, and it's the one that will be valid in law. So cross offer, on the other hand, you're both offering to buy something and you both don't know that you're making the same offer. For example, you offer to buy my property, okay, and then without you knowing, I also offer to sell my property to you. So we are both making the offer, we are both offering the same item, but we are unknowingly offering it at the same time. So the offers cross each other, so to speak. So that's why we call it a cross offer. And that cross offer doesn't create a valid offer. So it can't create a valid contract because they invalidate each other. There's no union of minds, so to speak. The other offer is a conditional offer. Usually when someone says, I'll give you 10,000 shillings if you do this and this and this. So that's a condition attached to an offer. An offer must be clear and concise and definite, not conditional. So these things make the offers invalid and eventually affect the contract that is created, because if the offer doesn't exist, then there's no contract created in the first place. So let's look at some of the rules that govern valid offers. Remember, we said the offer must be valid. So what are the rules that invalidate the offer or which make an offer valid or invalid? The first rule concerning offers is that an offer can either be made orally, i.e. by word of mouth, or it can be in writing, you write down your offer, or it can be by conduct. The way you conduct yourself, it is seen that by your conduct, you're suggesting something and you show an intention to be legally bound. That's pretty straightforward. Now, the other rule is that the offer must be firm and final. Remember, when we are talking about cross offers or counter offers, all those are not firm and final. They are negotiations, they are bargaining, they are things crossing, offers crossing. So those are not valid offers because an offer must be firm and has to be final. It's not negotiating, it's not what you're making your offer and you're bound by it and you intend to be bound by it. So the third rule is that an offer can be made to one person, it can be made to a group of people, or it can be made to the whole world. And there's a leading case on this matter, Khalil versus Kabolik, this case here. If usually we are saying that when you're talking about an offer being made to the whole world, you must talk about Khalil versus Kabolik. So let's just go through it so that you understand the case and why it's fundamental for this principle. It's a leading case on this principle in Uganda. So the defendant, that is a smoke ball company, advertised in the newspapers that had manufactured a drug called smoke ball and was preventing influenza. So the company promised that it will pay £100 to anyone who caught influenza or flu after taking their drug following the right conditions. So Khalil does so. He takes the medicine according to instructions and he falls sick. So he sues for his £100, saying that you guys promised £100 if someone falls sick. But the company refuses to pay Khalil's. So she sues for breach of contract. And court says that really the company was arguing that an offer cannot be made just blanketly like that to the whole world. It has to be made to particular people. So court said that an offer can be made to the whole world. There can be an open offer and can be accepted by anyone who comes up and fulfills the terms that forgive the sounds in the background. But an offer can be made to the whole world and can be accepted by anyone who fulfills the terms of the offer, the terms of acceptance. So that case is a leading case on that issue, that an offer can be made to one person or to a whole world. A blanket offer is still a valid offer. Rule number 4, an offer must be communicated to the person who is, to whom the offer is being made. And if you read this case of Fitch Snadaka, a $200 reward was offered if someone would be able to arrest a criminal. So this plaintiff Fitch, unaware of this offer that exists, the blanket offer that is existing in the world, he caught the criminal and then later he claimed his reward. But court said that he could not be given the reward because at the time he caught the criminal, he was not aware that there was an offer of payment for people who caught the criminal. So in other words, the offer must be communicated to the person to whom the offer is being made. You have to be knowledgeable of the offer for you to claim on it. Rule number 5, the offer must be lawful. Lawful in the sense that, remember we said the law does not uphold illegalities, or that you come to equity with clean hands. So it's the same principle here. The offer must be lawful. Things must be legal and it must not be crooked. So in this slide, I want to distinguish between an offer and an invitation to treat. Because many times when you have facts or a question, you find that you have to first decide, was that a valid offer or it was an invitation to treat? First of all, when you talk about an invitation to treat, we are really saying an invitation to make an offer. Like I put this picture of these sex workers. You find that when you see them on the street, they are not offering their bodies. They are asking you to make an offer. They are inviting you to treat. So invitations to treat or invitations to make offers are not valid offers. You cannot find her there and you say that you are standing there, you have already offered your body. No, she's standing there and inviting you to make an offer to her. She's inviting you to treat. So in the same way, goods on display in shops are only invitations to treat. If you go to a shop or a supermarket and you find goods there, those goods are not offered. They are asking you to offer to buy the goods, to offer to take the goods at a price you're willing to pay. So in this case, Fisher versus Bell, a shopkeeper was prosecuted for offering offensive weapons for sale by having flick knives on display on the window. And court said that the shopkeeper was not guilty as the display in the window was not an offer to sell but an invitation to treat. In the same way, this Pharmaceutical Society of Great Britain, this is a leading case on this matter actually. And I encourage my students that these are one of the cases you must remember. Khalil versus Kabolik, the one on the previous slide. Then this Pharmaceutical Society of Great Britain versus Boots. You must remember that because this is a leading case with respect to goods on display. What happened in this case? So Boots, most of you know Boots. It's a pharmacy or a drug chain or something in the UK mainly. So Boots, they're chemists. They had a self-service store like you see a supermarket in which certain drugs were listed. Certain listed drugs were displayed on the shelves. Now, according to the law at the time, it was an offense to sell those drugs unless the sale was done under the supervision of a registered pharmacist. So this customer goes to the, gets the goods, takes them to the counter, and Boots had the pharmacist at the cash till, at the cash desk near the exit, but not in the shelves where the drugs were. So Boots was charged with the offense of selling drugs without supervision of a pharmacist. And the issue before court was whether the contract or the offer is at the point of sale at the cash register or it is way before in the shelves when the people are still getting goods from the shelves. What did court say? Code says that the offer and the contract of sale takes place at the selling point where the pharmacist was. So there was no breach of law by Boots, because their pharmacist was at the place where the offer is made. In other words, what is this case saying? That when goods are on display in supermarkets, in shops, those are not offers for you to buy. They are invitations for you to come and make offers. Please remember that distinction. So this issue of invitation to treat is also seen with respect to adverts on radio, on television. You see those fancy adverts where they are putting nice things on these pancakes and you're like, wow, I go buy those pancakes. Those are not offers. When the advert is on TV of very nice furniture or of this nice car, that is only an invitation for you to go to the shop and make an offer. No one has made an offer to you. So you cannot go and say that you made this advert, you offered that when I eat the pancake, I'll go to heaven. Now it's not happening. No, that is an invitation to treat. That's why in this case, Partridge Crittenden, a person was charged with offering a wild bird for sale contrary to the law after he had placed an advert relating to the sale of such birds in a magazine. Court said that he could not be found guilty of offering the bird for sale, as the advert was simply an invitation to make an offer. In itself, it was not an offer. So this principle also applies to tenders, where they put tenders in newspapers, invitation to bids, for bids, invitation for tenders, or company prospectuses. When a company publishes its prospectus, when it's going to sell its shares on the stock exchange, all that is not an offer, and you cannot sue on it on contract basis that they have offered something and they are not fulfilling it. You can only sue for prospectuses, maybe with respect to there was fraud in the information they put, but you cannot say that you made your offer in this company prospectus, or maybe MTN is selling shares on the stock exchange in Uganda and they made an offer in the prospectuses, they gave us information, and then they don't fulfill that offer. No, that is an invitation to treat. Even invitations for bids, they're inviting you to make an offer. That is where when the bids are received, they look at your offers and then they accept what you have offered, or they reject what you have offered. So please remember to distinguish between an offer and an invitation to treat, because when you have facts in law, the very first thing you always have to ask yourself to establish whether there is a contract or at all, or a reason to even go to court or to sue or to challenge, is one, was there a valid offer? If there's a valid offer, then you say, okay, valid offer, tick. Two, was there a valid acceptance? Okay, so make sure you know that it's an offer and it's not an invitation to treat. So briefly, I'll talk about termination of an offer. How does an offer come to an end? If the offer is valid and we've agreed that it is valid according to the laws of offers, the rules concerning offers, if it's valid, what cancels out that offer? What changes that offer? What invalidates that offer? One, lapse of time. If an offer is made for a period of time and the time comes and nothing has been done, the offer lapses, it comes to an end. Revocation, on the other hand, means you cancel. You know, the offer is cancelled by the person who makes it. They change their mind. The offer also comes to an end if it is accepted by the person who is accepting the offer. If the person making the offer dies or becomes insane, that offer lapses, because remember we talked about capacity to contract. Insanity invalidates capacity to contract. So if someone dies or they become insane, the offer comes to an end. The counter offer, on the other hand, we said it comes to an end because the counter offer is the negotiations. The first offer is invalidated by the new offer, and then the new offer is validated by the newer offer, like that. Rejection also brings an end to an offer. Like, I offer to sell to you my Mercedes and you refuse. You rejected the offer. The offer lapses. It comes to an end. So number 2 and number 6 are different. Revocation is I change my mind. I revoke it. I pull out my offer, I bring it back. Rejection is it's not accepted. That brings the offer to an end. So now let me talk about acceptance. When there's a valid offer and there's valid acceptance and of course consideration, we have a valid contract. Actually, we have a valid contract if there's a valid offer and that offer is accepted in a valid way. Now, for you to be able to sue on that contract, you have to have furnished consideration. So these 3 really bring about a valid contract that can be enforced by someone. So now I want us to talk about acceptance. Let's look at the rules. What are the different rules that govern acceptance? Because the offer must be valid, but also the acceptance must be valid. There are valid rules, or there are rules that govern acceptance. What is valid, or what is acceptance according to the law. Now let's look at the rules that govern acceptance. And by acceptance, we are saying you're willing to be bound, you're accepting, or you're allowing to be bound in this contract or in this deal. So one of the rules, number one, is that you're accepting to do something can be written, it can be said by your word of mouth, or by the way you conduct yourself. If you go to these sex workers and you make your offer and they hold your hand and walk away with you, that is their conduct of acceptance. So acceptance can be by conduct. It can also be, acceptance must be absolute and unqualified. Why? First of all, what are we saying? We are saying it must be, yes, I have accepted. No, not, yes, I've accepted, but first do this. Or because if you put the conditions, or there are changes, then it becomes a counter offer. Remember our counter offer. So acceptance must be absolute and unqualified. In other words, it's not conditional. It's purely accepting what is on the table. No more conditions. You accept things as they are. That is what is valid as acceptance. Acceptance, number three, must be communicated by someone who has the authority to make the acceptance. There's a leading case on this matter. There's a guy who was being offered a job, and before the company officially communicated to him that he could come in, someone tipped him off and told him they've allowed you to come in. Then the company, before communicating to him, they changed their mind and nominated someone else. So he sued, saying that you had allowed me, now you've changed your mind. The law said that no, they had not accepted to you. The person someone else just tipped you off as a side tip, but that was not official acceptance. So in other words, acceptance was supposed to be made by the company that made the offer. So also acceptance must be communicated, number four, to the offerer in the manner stated by him. If I ask you that accept my offer by sending me an email, and then you call me by telephone, that's not valid acceptance. You must accept by email in the manner in which I have said you must accept. There are cases on all these issues. I just don't bring them up here because I want you to understand the principles. Then you can go back and apply the cases. So number six, acceptance is not effective if communicated in ignorance of the offer. In other words, you accepted something, but you did not know originally there was an offer made. It's the same case as the other guy who caught a criminal and did not know there was an offer, pretty much. You remember that law has to ensure there's union of mind. So you can't accept what you didn't know existed. You didn't know that offer existed. You can't accept what you don't know. There was no union of minds. So in other words, acceptance must be made with the knowledge of the offer. So like I've said, there are leading cases on all these principles. Please don't ignore the cases. They carry marks too. They carry 2 marks per case almost. Here in these videos, I'm mainly explaining the principles so that you understand them, and then you can apply the cases. So the 7th rule is silence does not amount to acceptance. In other words, if I make an offer to you and you don't say anything, I am not supposed to read your silence that you have consented to me. There's a leading case on this, Feldhaus versus Bidley. It's very famous for this matter. So the plaintiff writes to his nephew to buy his horse, and he says, if I don't hear from you, I'll consider the horse is mine at £30 and 15 pence. The nephew didn't reply, but told his PA not to sell the horse to anybody else. Now the PA in error sold the horse, and Feldhaus came suing, says that you didn't say anything, it meant you accepted, and now you have sold the horse. So the issue before court was whether silence by the nephew amounted to acceptance. So court said that since the nephew had not said anything, he had not communicated his acceptance to the plaintiff, there was no contract of sale, there was no acceptance. So the PA or the auctioneer was not liable for the sale. In other words, silence does not amount to consent. If I'm quiet about something, I'm not consenting to it. The other rule is the postal rule. The question has always been, at what point is acceptance deemed when a letter is being posted? Is it at the time you post it? What if it delays? Is it at the time you receive it? Is it at the time the postmaster gets it in the country it's arriving in? So the principle of law is that acceptance is as soon as that letter is well addressed and posted. As soon as it's well addressed and stamped and put in the post box, that cap box, then it is deemed to be valid acceptance. So that's why you see there is always a stamp with a date on posting letters, because that date and time determine what time acceptance was done. So if the thing is sold when acceptance has already been done, achieved through the postage, it means that sale is an invalid sale, because at the time of the sale, acceptance had already been done, so there was a valid contract existing, and the seller was no longer able to have power to sell the item again. So remember the rule on silence and the postal rule, they're always very important, and there are cases on the postal rule as well. Please look it up. I hope this video has made it easier with respect to the law of offer and the law of acceptance. Please remember you must have a valid offer and a valid acceptance so as to have a valid contract, and once you furnish consideration, then you can enforce that contract. So do not hesitate to contact me in the comments on what other topics you want me to talk about, and I hope you have yourselves a very good day.